Hi, this is Carol Ray with Notary to Pro. I want to welcome you to Phase 2 of the Professional Signing Agent course. We're going to be covering a full set of typical refinance loan documents in this Phase 2. I will be guiding you through each document verbally as you look at the documents on this webpage. You will be able to download and print these documents if you prefer, or if you're having trouble reading them on your computer screen. Please pay attention to the notes on the documents. They contain crucial information. Before we get started with the documents in this typical loan package, I want to address both acknowledgments and jurats because these are an important part of the document signing process. As notaries, we are called upon to notarize many different types of documents, some of which may require us to take an oath or an affirmation from a signer. What form we use to acknowledge that we have witnessed the signing is directly dictated by this process. The true definition of an acknowledgement is a formal declaration before a notary public that the instrument presented is the free and voluntary act of the party executing it, and the signatures on the document are genuine. On a certificate of acknowledgement, it must contain the state and county where the document is executed. That's important to remember. It is where it is executed, the date of the execution, the name of the signing parties. It also has to contain the printed name and signature of the notary public, the seal or stamp of the notary public, and the expiration date of the notary public's commission. More and more states are now requiring that if an acknowledgement is being attached to a document, it must contain information which directly ties it to the signed document. This would include the name of the document that the acknowledgement is being attached to, the signer's names, the date of the signing, and if there's multiple pages of the acknowledgement, it can be given a page number. So as an example, let's say that the document is 3 pages. The separate acknowledgement that's being attached to it as the last page would be marked page 4. So of course the acknowledgement will contain all of the required information for the notary public. After these pages, the first documents you will see are both an acknowledgement and a jurat. A jurat is defined as an attached written statement of the notary public that the oath or affirmation was taken before the notary public. Taking the oath or affirmation is an indisputable requirement, regardless of what state you are commissioned in. That's important. You must administer the oath. The oath is a promise that one is making a true and correct statement to the best of their knowledge. And also, before I go any further, I want you to know that we do have videos available, very specific videos on how to do acknowledgements, how to do jurats. How you take your oath, how you take the oath, and whether or not you've have the person taking the oath raise their right hand or not, or the exact wording of the oath is to be determined by the dictates of the rules and regulations of your state. Please, before taking an oath, learn those rules. It's imperative that you adhere to them. There's actually 3 components when it comes to administering an oath. You want to ask the signer to attest to the truth of the information given. That goes to accuracy. You want to ask the signer to attest to the truthfulness of who they are, which goes to the component of identity. And last but not least, ask the signer to attest that they did not make any false statements, and that is for the truth. An affirmation is an oral or written declaration made by a person who has an objection to taking oaths, that they are certifying under the penalty of perjury that the declarations are true. Now, the contents of an affirmation must include, again, the venue, which is the state and county where the document is executed, the date of the execution, the name of the signing parties. It also has to contain the printed name and signature of the notary public, the seal of the notary public, and the notary public's expiration date on their commission. There is a difference between an oath and an affirmation. A typical oath will be, do you solemnly swear that any statements made when signing this document are true, to the best of your knowledge and belief, so help you God. Typical affirmation would be, do you solemnly, sincerely, and truly declare and affirm that the statements in this document are true and accurate, to the best of your knowledge and belief, and this you do under penalty of perjury. Okay, I want to talk about the seal a little bit. On most documents, there's a specific area where the state, county, signer's names, date of signing, notary name, and signature line are included. This is usually found at the bottom of the documents, as you'll see, below the signatures of the document signers. There is also usually an area near the notary's name that's sufficiently large enough to contain your notary seal or stamp. When you place your seal or stamp in this area, it must be clear, dark enough to photocopy, be complete, and must contain the state where you're commissioned, the name of the notary public, and the word seal or a picture of the state seal on it. Now, don't forget, if you fail to place your stamp on the documents have not been officially notarized and they will not be usable. Now, there are several items that must be included on the document in order to be notarized. You have to have the name of the signer, has to be typed, printed, or stamped below the signature line. The signature must match the name of the signer on the documents, which has to match their identification. And we get into that more in the advanced course. It's very tricky, difficult to understand, but it's extremely important that you do. It also must contain the printed name of any witnesses, and their names are to be printed under their signature line. And the notary's printed name must appear below their signature line as well. Now, if you ever have any doubts about whether or not you're supposed to stamp a document, try to remember it this way. The document that's completed and or signed by you as the notary, but it's not signed by the document signer, will not be stamped or sealed. You are never to stamp any document that you are not actually notarizing. And that brings up one point, that there are occasionally companies that will send out a document and they say, we want to make sure that you are a commissioned notary, so please put your stamp on this page. No. And if they do that, say, sorry, but it's against the law, because it is. You're not allowed to apply your stamp or seal to anything other than those documents that you are actually notarizing. Also, a document that is signed by a document signer and you as the notary, that does require your seal. A document signed by the document signer but not by you as the notary is not to be stamped or sealed. So basically, I just want to go through just a couple of points on a regular acknowledgement. Everything's pretty obvious. You're going to put the state where you are commissioned and where the signing is taking place. I do want to say that on the county, it has to be the county where your feet are planted when you are doing the signing. It is not the county necessarily where the property is located, and it's not the county where you are commissioned. It is always the county where your feet are planted while you're doing the signing. Very important. When you see if this is a blank thing, you need to know how to fill this in. So after the word on, that would be the date, and that's always the date of the signing. You're never to change that date. If somebody begs you to say, oh, could you please put the day before this? My documents are going to expire. Boo-hoo-hoo. Never, never, never backdate. You can lose your commission by putting a date other than the date of the acknowledgement in there. Before me would be your name as the notary public, and then personally appeared would be the name of the person or persons, because you can list more than one person on an acknowledgement, so that's what would go there. The crossouts are kind of important when you get down to this, where it says who proved to me on the basis of satisfactory evidence to be the person. This is just one person in this one, Marvin Reynolds, whose name is subscribed. You're going to cross through the R. And then when it gets to the acknowledged to me that he executed the same in his authorized capacity, and that by his signature. So you can see that whatever does not apply, you just put a line through. So of course, obviously, if it's more than one person, then it would be whose names are, that they executed, etc. You're also going to be swearing under penalty of perjury under your particular state. Some acknowledgements have that for your state, others do not. If you receive one that is for another state, and it says that you promise to certify under the penalty of perjury under that state, you can't do that. You're not commissioned there. So you're going to need to use probably a separate acknowledgement, which would contain the wording that's required by your state. Now, the rest of this acknowledgement, as you can see, this is a separate acknowledgement, and this is what I was talking about earlier. It does have this box on here that's the description of the document. So what you would be putting here is, first of all, the name of the document. Let's say it's a power of attorney, and then you would put whatever date is on that document, not necessarily the date of the signing. Let's say the power of attorney has 4 pages to it. Well, this actually, because it's being attached to that document, it shows that the number of pages is now actually 5. Now, here's for additional signers. And let's say that there's 2 people signing that power of attorney, but only one of those persons is appearing before you, and you're acknowledging just Marvin's signature, not his wife's. Then you would put the wife's name under additional signatures, because as you can see here, it says additional signers other than those named in the notarial certificate. Now, also, just because I lived in Arizona for quite a long time, one of the first things I did as a professional signing agent was to go to the state site and download some documents to keep them on my computer, and this was one of them. This was the official separate acknowledgement. I knew that I would be needing them. It's a really good idea, if you can, to go ahead and download some of these documents that you're going to be needing, and that way you have them, you're ready, you can fill them in on your computer, you can print them out, you can do whatever you want with them, and you're not scrambling at the last moment to try to find one if you need it. Now, oftentimes, this is what this will look like when you are doing a jurat. It will have, and as you can see, I've used the state of Arizona form, but most of these are pretty common throughout the United States. The important thing is that on jurats, the words that are subscribed and sworn to or affirmed will appear on them. And being subscribed and sworn, obviously, it means that you're going to be administering an oath to them. And it's filled out pretty much the same way as any acknowledgement, as you can see. Okay, one of the things that we're going to be talking about is critical documents. If you've already been through the phase 1, you know that we have discussed this, how important it is. This is the HUD-1 settlement statement. This is the absolute first thing that you want to go through with the borrowers. The reason for that is that oftentimes there is inconsistencies on the HUD, and if that's the case, it has to be addressed immediately, because the problem is that if you have this sometimes where they put them, which is at the end of the documents, you go through the entire document signing, and all of a sudden you've got an issue with the HUD-1 settlement statement. It puts a stop on everything, and you have wasted all of that time. So very important. The first thing that goes that's presented to the borrowers is the HUD-1 settlement statement. Now, this particular statement is for a typical refinance. I really apologize if these are not large enough for you to see. You might be able to make them full screen. I'm doing a new recording here, hoping that the method that I'm using will allow you to do that. But basically, I've made this very simple. The only thing that I really want to point out at the top is, of course, you've got the names of the borrowers. If it was a seller, if this was a purchase, it would be there. You have a name and, of course, a typical address of the mortgage or lender. Also, the property location and place of settlement. Now, I have put a yellow sticker thing over something that's for the settlement agent, and this is where you would find the name of the title company and the address. This is important for one reason. When you are needing funds from the borrower in the form of usually certified funds, and I'll get into that in a minute, you would need to advise them as to who that check is made out to. That information is found in that square, which is the settlement agent. It will give you that information. Sorry, I covered it up a little bit. Okay, we're going to go through just a few things here on the HUD. I made it really simple. You have here the settlement charges. And I show here that the settlement charges are $5,000. Now, this figure is an addition of all of the costs that's involved in the loan to the borrower, and it must match the figure that's at the bottom of the next page, and I'll show you this as well. Also, you're going to come down here to line 110, and you'll see that this is the payoff to the existing loan of record. In other words, they have a first on their property, they owe $182,500, and obviously that must be paid off before the new loan takes place. So it's kind of all happens all at the same time. Wired funds are sent to the lender of record on the same day of the... Okay, the gross amount due from the borrowers here would be $187,500, and that's the addition of the settlement charges plus the payoff. The next thing that you're going to see here is the principal amount of the new loan. The principal amount of the new loan goes as a credit, acts as a credit. So when you see down here, you're going to see the total amount paid by the borrower is $200,000. What you're going to be doing is looking at the gross amount due from the borrower, which is considered a debit, and the gross amount just above the credit of $200,000 for the new loan, and the difference is $12,500. And this is the amount that the borrower is going to be receiving at the close of escrow. These funds will be dispersed on the same day that the escrow is closed. Now, sometimes you will see that they have money due from the borrower, and that happens when the debits are larger than the credit. So let's say, for instance, in this particular case, there was a loan of $180,000, the new loan, then they would actually have to come up with $7,500. Now, just so you'll know, most funds have to be paid in the form of certified funds, which means that they have to get a certified check or cashier's check from the bank, or they can wire funds into the title company. Now, many states do have certain limits. They might say, well, for the first $5,000, you can make a personal check. It's usually called a good funds law. Oftentimes, though, you will find that a title company might say anything over $2,000 has to be certified funds. So you have to read your instructions, and if they're not in the instructions and the borrower has to bring in funds, then it's really a good idea for you to find out what they expect, if the title company does need those in certified funds, or if they'll take just a personal check. Never a money order. Money orders can be canceled, so that's a problem. So you just need to check and verify that. Okay, now here is the second page of the HUD-1, and this is just a very simple breakdown. You will see fees like the items payable in connection with the loan, such as the origination fee, the appraisal fee, the credit. So this area down below is the impounds. Impounds are also called reserves. They are also called escrow account, and this is money that the borrower pays with their monthly payment. They'll have a principal and interest payment on their loan. They will also be paying maybe their taxes and insurance based on a divided amount. In other words, let's say that their taxes were $1,200 a year, it's divided by 12 months, so it would be $100 a month that would go into the special account. And that way the lender has enough money to pay those taxes when they become due. Same with the homeowner's insurance. But because they're starting off fresh, in order to collect the whole year and have enough money to pay it, they need to collect some money in advance. And that's what this is all about on the HUD. They're collecting whatever they need to have enough money 1 year from now or 6 months from now to pay that bill when it comes due. Okay, as you can see here now under title charges, there's usually much higher fees, but I put down here $100 for the title fees, and I put down here $400, and that is for the lender's title insurance. And this is important to remember, and I have a little sticky here. On a refinance, the only title policy that's issued is a lender's policy. This protects the lender from any unwanted liens and judgments, etc., against the property. As an owner's policy, this is going to be on the test, an owner's policy is issued when the property is purchased, and it protects the owner of the property for the duration of the time that they own the property. In other words, when they get that owner's policy, when they purchase the home, it's good until they either die or sell the home. Down here at the bottom, you can see that this figure is $5,000. We do our comparison. That figure does match that settlement charge that shows on page 1 of the HUD. The only other important thing for you to know, I didn't put any figures in here, is that this area where it says comparison of good faith estimate, the GFE, good faith estimate, and the HUD-1 is put here. Basically, good faith estimate is sent to the borrowers ahead of the closing, and this gives them a pretty rough idea of what's going to be charged to them. They don't know the absolute final charges until the closing and the loan documents prepared, and what's on the HUD-1 is the final say-so. So what they can do here is they can compare those figures to see if they're any different. In other words, if the title lender's policy was going to cost $428, and now we see that it's only $400, then the borrower knows that, oh, I saved $28 from then to now. So this is the end of the HUD. There's oftentimes a few more pages, but they're pretty easy to figure out, signatures and so forth. Do keep in mind as we go through this that you will be able to stop at some point if you want to and then come back later on. The arrow at the bottom of the screen is manipulative. You can move it. It might take just a little bit of time, but you can just mark where you ended up and then you can go back to the same point. Okay, here's another very critical document. That is the note. This particular note has a fixed interest rate on it, and you can tell that by a couple of things. First of all, if it just says note at the top, it means it's a fixed rate. It doesn't say anything. It doesn't say adjustable. It doesn't say there's a balloon payment, anything. Also, I'll show you in a few minutes, the words fixed rate can be found at the bottom of the note in very small letters. And if it was another type of loan, such as an adjustable rate, it will state that in writing at both the top and the bottom of the note. Now, there's some crucial things that you need to go through on a note. This is very important. The first thing that you're going to go through is the amount of the principal of this loan, and the principal balance of this loan is $250,000. Keep in mind, that is the principal amount of the loan. That does not include the finance charges that have been rolled into that amount. The interest rate is something they definitely want to know. The reason that we have these critical documents and started doing this years ago is because we found that when people were, we started going through documents, oftentimes these documents are sometimes at the middle or even at the end of the package, and we would start and people would say, well, how much is my interest rate? So we'd thumb through, find the note. Oh, your interest rate is 4%. Okay, now we get back to where we were. Well, do you know when my first payment's due? Thumb through. So this is to save you all of that. When you put these critical documents on the top of the stack, your signing is going to go so much better because all of the questions that the borrower has and that they are entitled to the answers of are all in these critical documents. So back to the note. This will tell them when their first monthly payment is, which is August 1st, 2011 on this one, this kind of an old note. And then it will show them the last payment due, which is July 1st, 2026. Simple form of math, you can see that this is a 15-year loan. You're also going to be able to tell them what their monthly payment is, which in this case is $1849.22. Now keep in mind, and you must tell them, this is your principal and interest only, because if they do have impounds, you don't want to tell them their payment is this amount, and then in a couple of pages they find out it's over $2,000 or something. Then they go, how did it go up in just the last couple of minutes? So just remember, this is the principal and interest only. Another thing I think that's very important to point out, although very few loans nowadays do have the prepayment penalty, so you need to just read it, and here it says that they have the right to make the payments on the principal. A few years ago, we had a lot of people who had loans, and this was prior to 2007, they had loans that had a lot of prepayment penalties, and we'd be going through the documents, the HUD especially, and it would show that someone was having to come up with, say, $8,000 for a prepayment penalty, and they'd go, what is that? We'd explain, it's for paying it off early. They were refinancing, getting a better rate, and we would say, you didn't know that? They would say, no, nobody ever told me that we had a prepayment penalty on our loan. And I would say, no, your loan officer didn't, nope, nobody told us. And how about the notary when they were going through the note with you? And what we would hear all the time is, the notary, they just came in and threw the paperwork at us and said, sign here, and left, and that was it. That is why we go through these documents with them. We're not giving them any kind of advice. People say, oh, you shouldn't do that because then you're giving it's the unlawful practice of law, which is UPL. No, you're only showing them what was written on the paper in front of them. And people sometimes have a very difficult time, absorbing that information. So even if they get their documents ahead of time, unless they really understand what they're seeing, they don't really understand it at all. The only other thing that I usually go through with the borrowers is the late charge. The way I like to say it, because it just sounds a little better, is you have a grace period of 15 calendar days. And if your payment comes after that grace period, you will be charged whatever percentage. On this one, it's 5%, and that is of the principal and interest payment. If you're ever wondering, that penalty is the percentage of the principal and interest payment. Now, one other thing, on this particular note, every page includes a place for initials. You can have, if you've got more than one borrower, they can fit those initials in there somehow, even to the left of the initials. Also, just remember that when people initial, they must include all of the initials that are contained within their written name. So if they're signing their name, George W. Clotter, he has to have GWC on the initials line. And of course, last but not least, this is the last page of the note. A note, I can't say never anymore because there's a company in Virginia that requires people to notarize their note. But 99% of the time, there is no notarization on a note. There's no verbiage for the notary to read, sign, fill in, or complete. So just remember, don't be looking for a place to notarize on the note. Also, you want to make sure that they sign exactly as their names appear on the document, but their identification has to support that name. Okay, the next critical document is the notice of right to cancel. Every loan that covers primary residence is allowed to have the right to rescind that loan, and the document used for that is the notice of right to cancel. Now, keep in mind that this is not available to people who are borrowing on investment properties, second homes, commercial properties. This is strictly on primary residence. Now, when you're going through the notice of right to cancel, you might say to the borrowers, I know you don't want to cancel this loan, but just in the event that something should happen and you should choose to cancel, I want to show you how to do that. You can then go through this document with them and instruct them as to where to sign. You might want to put a sticky note on this place where it says, I wish to cancel. I don't know why, but a lot of people want to sign there accidentally. Okay, so the first thing that's going to be there, and it really should be already pre-printed, but oftentimes it is not. You can always put the date of the signing for the transaction date. If this date is incorrect, let's say that it's June 20th, 2011, but you're signing the documents on June the 22nd, you want to put a line through that and then put in afterwards or on that line, June 22nd, 2011. I do suggest that if there's corrections to be made to any of these documents, that you try to call the people that hired you to see how they will allow you to do that. Some companies do not allow crossouts at all, even if it's their own mistake. Also, you can show them here, this is how you do cancel. If you decide to cancel, you can send a copy of this document to this company. This is where you do it. And usually it would be, of course, by probably email or fax. Also, one of the things you want to watch out for is to let them know that if should they decide to cancel, to please call their loan officer as soon as they make that decision. We had a woman a few years ago who waited until the last moment to cancel. She put her cancellation notice, the notice of right to cancel, into the mail, and it was postmarked. Okay, it was postmarked in time, but it was like, 9 o'clock at night on the night of cancellation. What happened is the day after the rescission was over, which was the following day, they funded the loan and they recorded all of the documents. And then they got, a couple of days later, they got this notice of right to cancel completed in the mail. They had the legal obligation to go ahead and cancel it because she got it in the post office in time. But what a nightmare it was trying to back out everything. All of the documents had been recorded, all of the funds had been dispersed, and it was a mess. So as you can see here, they give you the rescission, the end of the rescission date, and we'll go more into that at the end of these of this document section. I do have something on rescission that's pretty detailed. Also, don't let the borrower sign where it says I wish to cancel. And that was what I was saying before, that what you can do is to put a little sticky, one of those sticky notes over that area so they don't accidentally sign there. What they are doing is they are signing here at the very bottom, as you can see here, by putting their signature and the date, and it has to be that date that you're acknowledging their signatures. And this is very important. For every borrower, they need to have 2 copies executed. In this particular case, you have Mr. Greg Amayatest, 41. He has to execute 3 copies of the notice of right to cancel. One of those copies goes back to the lender with the loan package. He is entitled to keep 2 executed copies. Do not leave any blank copies with the borrowers. You must have them execute their copies while you're sitting there with them. The reason for that is that should they decide that they want to cancel for some reason and they've got a blank copy, that can be manipulated to appear legal. So what you do is leave 2 executed copies for each borrower. Even if they sign the same document, they each have to execute 2 of those copies. This is the itemization of the amount financed. Basically, this is just a complete breakdown of all of the fees that are being paid on this loan. As you can see, it includes payoff, title insurance, any kind of fees, the appraisal fee, all that kind of thing. And it shows that the amount totals to a certain amount here, and then the amount of the loan, which is $245,000. This also is not notarized. At least I've not seen any yet. Okay, now this is a deed of trust, and most refinances are going to contain one of 2 security instruments, either a deed of trust or a mortgage. Now, what makes them different is the fact that on this security instrument, this has a trustee involved. And the trustee handles foreclosures. In the event that there is a foreclosure, there's a difference between a mortgage and a deed of trust. With the mortgage, the lender is responsible for taking care of a foreclosure. They have to go through the court system. They have to go through the sheriff's department in order to get that done. On a deed of trust, there's usually a trustee that's appointed to take care of that situation. So just remember, that's the big difference between a mortgage and a deed of trust. So on the deed of trust, you'll see here we have the name and the vesting. The vesting is how they're taking title. This man is taking title as a single man. You want to check the name on this, make sure that all of the documents do match the name on the deed of trust, because this is the way that they are on title. On this particular page, they're going to be initialing. And as you can see here at the top, this is the trustee. D is First American Title. So again, they will be handling any foreclosure proceedings. They'll also be issuing a reconveyance when this loan has been paid off, to take that cloud off of the title. Okay, also you'll see that the only things on this regarding the note itself, they don't put the interest rate or anything like that on it. It's strictly the date of the note and how much that note is for and when is the last payment due. Now this is important, these boxes here. These boxes, which may or may not be checked, but let's say, for instance, that it's a condominium that these people have. And if there's an X here. If, in fact, attached to this deed of trust, you do not have a rider, a condominium rider, to be recorded with the document, you have a problem. So what you need to do is to call the vendor that hires you, or the lender, title company, whoever it is, and tell them, you know what, I have my deed of trust, but I did not get the condominium rider, and it is indicated in these documents that this is a condominium. Okay, as you can see from my little sticky note, you're going to be asked sometimes if anyone has actually read the entire deed of trust. Not on my watch. The answer to that is in phase 1 of the course. But for right now, let's just skip to page 24. The only thing that appears on this page is just the address of the property. Okay, this is the basically the last page of the deed of trust. There's a lot in between. You do not need to go through the deed of trust with the borrower. They will have copy. They have that 3-day right of rescission. There's really nothing in there that they're going to be able to change anyway. So this document needs to be signed. And then, of course, this is the acknowledgement that appears on that document. It is part of the document. So as you can see here, you'll put the venue is your state, and where your feet are planted is the county. It goes in there. Just remember, if you're commissioned in Brown County, but your signing is taking place in Orange County is what's going to go into that area. Then you're going to be doing the date of the signing before your name. Sign it here. Also, underneath the signature line, put your name, print your name, and the fact that you are Notary Public. So it would be your name, Notary Public. You can even sign it, your name, comma, Notary Public. Also, you want to make sure you put your stamp in this area and make sure it has no smudges. It's perfectly clean so that it can be recorded. From this point forward, I'm really going to be going through things pretty closely. You can, when you print these out, you will see all of these instructions and things highlighted and everything. Also, when you do print these out, this is really important. In order to get these markings on here, when you go to print, you need to see where it says what you're printing. It'll say documents. Open that up because it should say documents with markings, and that's how you want to print that out. Make sure that that's marked. It depends on your printer. Some of them will do it automatically, some will not. So basically, this is just instructions. Primarily, it's about the loan, and the instructions are basically for the title company, escrow company. As I said, these instructions are primarily for escrow or title, and they just tell them what the requirements are, how much the title policy has to be, what's required on the title policy, how much hazard insurance. And hazard insurance, by the way, is homeowner's insurance, but they always call it hazard insurance. The third page of that document we were just looking at has a signature I want you to pay attention to. It says settlement officer. You are not the settlement agent. You are not the settlement officer. You are not the closer. You are the Notary Public. Okay, last but not least, it's just a breakdown of the cost. This is basically the same thing that was on the itemization of the amounts financed. This document is an escrow waiver letter, and this is in the event that the borrower is going to be paying their own taxes and insurance as opposed to setting up an escrow account. This is a lender requirement that they state that, yes, they're going to be paying their taxes and insurance, and they're going to do it before any penalties are levied or anything like that. Now, if they fail to make those payments, let's say they don't pay their taxes, then this gives the lender the right to take some action to make sure that those taxes are taken care of. This document basically is just a warning to the borrower that this loan has been sold and it will be handled by JP Morgan Chase. Shows what their principal and interest payment is. If there was impounds for taxes and insurance, it would also be included there. This is basically just showing the borrower what type of homeowner's insurance that this lender requires. As you can see here, there's a couple of requirements on here, including the company must have an A rating. And here is the second page of that that document. And since this is a 3-page document, this is the 3rd page. They're just going to sign and be sure that they date the actual day that you are witnessing their signatures. This is pretty self-explanatory. This just states that the borrower is entitled to receive a copy of their appraisal if they have not already done so. If, for instance, you're signing them and they say, oh, no, I haven't gotten a copy yet, you don't really want to hold up the entire loan. You can't give them advice. You have to leave it up to them. Most of the time, they'll say, no, it's okay. I'm just going to call Joe, the loan officer or whatever, and get a copy. This is a compliance agreement. This is basically signed by the borrower stating that they agree that if any documents have been left off, if there's any clerical errors on the documents, they agree that the lender can take care of it without bothering them. They can't change the amount on the loan or the interest rate, nothing like that. It's mostly just something to do with information. And again, here's another acknowledgement. We'll skip this one. Now, this is kind of an important one you want to know about. When people are reading this, they're going to misconstrue this and think that they have to have flood insurance on their property. And most of the time, what this basically says is that there's no flood hazard determined and that they do not have to have flood insurance. But if it ever is designated as a flood hazard area, there will be government assistance to obtain flood insurance. This tax record information sheet, you just need to turn that over. Don't even go through it with the borrower. They don't have anything to do with it. This is strictly for the lender. This servicing disclosure statement basically says that they may assign, sell, or transfer the servicing of their loan. And on this one, they have sold the loan. Each box is able to be have an exit, so you'll see when you read it to them or show it to them what the determination is. Again, here is a notice of sale or assignment, and it does show that they have sold this loan to JP Morgan Chase. This is just a directive to the lender and the insurance company as to how the mortgage clause is going to read. This is just a sheet that shows what kind of disclosures are being sent to and showed to the borrower. Okay, this borrower certification, the certification part of it says that they have been truthful in completing their loan application, and the authorization is to give the lender authorization to release certain personal information about the borrower so that the loan can continue and be made. This 4506T is an important document. It actually is giving the lender the ability to be able to have permission to take get your tax transcripts from the IRS, and it's usually designated as to what year it might be. Also, you can see that only one person's name is on this, but if they do have a spouse and it's a joint return, then the spouse's name and social security number would be on this document. And what you need to do also is be sure and verify the social security numbers. Just have them look and make sure that they're correct. So if there's a spouse, the spouse's name will be in there, and they'll also have to sign this document. So as you can see here, these are the years that they're asking for, and then you're going to have the person sign, the date that they sign, and then the signature of the spouse if there is one. This is just a typical W-9, which is something you're going to have to complete and have ready to send out to the companies that hire you. This is for the purpose of reporting to the IRS any funds that have been paid to you. Now, for those of you who do not know what a TIN is, it's a taxpayer identification number. There are people who use these identification numbers. My husband and I actually use them as opposed to our social security number. I don't like our social security number to be on anything, especially when I'm sending it out to people I don't really know. By signing this document, the taxpayer is actually saying that this is their correct either social security number or taxpayer identification number, and they can be held liable if they're lying about it. They can be prosecuted. Okay, this is an important document. They come in all different forms. The first thing I want to point out to you is that the word affidavit, it says signature name affidavit. What that means is this is one of those documents that you're going to have to administer an oath. Now, here's what I suggest. You can do it whatever way you want. Everybody has a different way of doing it. An oath is absolutely mandatory. I've talked to a lot of notaries who say, oh, I don't do that. Well, let me tell you what the consequences can be if you don't. First of all, when you administer an oath, the best thing to do is to administer it before you get the signing started. What you'll have the people do is to raise their right hand. They don't have to, but I think it's a good idea. You're going to read the oath to them, make sure that they say I do or whatever words you determine. And then you're going to tell them that this oath is going to be in effect throughout the entire signing of the documents. So anytime that you come to something such as an affidavit, the oath is still in effect and they're still promising that they're telling the truth. Then when you come to these affidavits, anything that has to be sworn to, you can just remind them again. Say, I just want to remind you that you are still under oath. It saves a lot of time. You don't need to stop every time and read them the oath. Now, on a signature affidavit, this is something that's very valuable form for you. Let's say, for instance, that you have a person who is known as, let's say that you have a woman who has gotten married, and on the documents there's nothing but her maiden name. Her driver's license now, whatever identification she presents to you, shows her married name. But on these documents, it's her maiden name. She doesn't have any other documentation to prove that she is that same person. So oftentimes the lender will take care of this. If they don't, you need to talk to the lender or to the vendor and let them know about the discrepancies. And what they can do here is they say that this person, in this particular instance, they're also known with their initial, but everything shows just the name without the initial. Then you can put in that name, like for a woman, you can put in that maiden name. I am also known as this person. You administer the oath. They've sworn to the truth. You're fine. Now you can identify them without a problem. So this is a signature name affidavit. They come in different forms. They're very important documents, and they do require the oath. This is an affidavit of occupancy. Basically, it says what if it's a second home, investment property, primary residence. And again, it's an affidavit, so they're swearing under oath that this is true. They could get into a lot of trouble. It's called fraud if they were to say that it is their primary residence and it's found out to be a rental property or something. Okay, this is a document that's important to you as a notary signing agent. This information contains the name and address of the property. It also has the social security number or tax ID of the borrower. And on this particular one, they want to have one form of identification. Some of them require two forms of identification. So what you're going to be doing is you're actually going to be taking the actual, let's say in this case, a driver's license, or it could be military ID, passport, any one of these items that are listed here on the first document list they will present to you. You need to very carefully examine that driver's license or whatever they've given to you, and you're going to be completing the information here, the country, country or state of identification, origin, the ID number, the date of birth that shows on that identification, and the expiration date. Fill that in. If there is a second form of ID, then there is a list here that they give you of things that can be used. If it's a social security card, you have to actually look at the social security card. Any one of these things you actually have to observe for yourself. The reason for that is because you are going to be signing, you're the only one that's going to be signing this, that says that you certify that you have personally viewed and accurately recorded the information from those documents identified above, and that you have reasonably confirmed the identity of the borrower. When you sign this, you're going to be signing your name here, and then over here, you're going to be printing your name with a comma, either signing agent or notary signing agent, along with today's date. So this is one form you do not sign as a notary public. You are not acknowledging or witnessing the signature. This is not to be notarized. This is not to be stamped. So just remember that. This is an important form. This is just an Equal Opportunity Act notice. It's just a disclosure, one of many that the borrower will be provided. This is a funny one that says basically if you don't make your payments, they're going to report you to the credit agencies. Now this document is called an amortization schedule, and if you're not familiar with this, it's very simple, but it is something that the borrowers are usually pretty interested in. And basically what this does is it shows that the number of the payments as they're made, and it shows the payment date that it's due. It shows the payment amount as it's to be made, and this is the principal and interest payment. And the fact that it's the same payment every time. Now, if they pay more on their payments than what is due, then this amortization schedule is going to be thrown off. But it shows how much of that particular payment goes toward the principal, how much goes toward the interest, and what the balance is on the loan. So let's take payment number 48, which after 4 years of owning this property and making payments, shows that the payment that's due at that time is July 1st, 2015. The payment amount is $1849.22. You have $1187.88 going to the principal, $661.34 going to the interest, and it shows the balance and what it is at that particular time. So as you can see here on the next page, at the very bottom, after the 180 payments have been made, which is for the full term of the loan, the last payment due is $7,126. The payment amount has been adjusted to $1849.15. And then the amount that goes toward the principal is $1843.01, and the last little bit of interest, $6.14, and their house is paid off. And this again is called an amortization schedule. Now this is the Uniform Residential Loan Application, also known as the 1003. And it's kind of important for you to remember that because oftentimes somebody's talking about it, they won't call it the residential loan application. Let's say, oh, on the 1003, we have on additional resources a complete breakdown of the terms used in this industry on the glossary. So look for the glossary. You can actually print that out if you want to. All of those documents, just be sure you download them to your computer and then print them out. Okay, so on the 1003, a couple things you need to know. First of all, at the top of the 1003, the only people that will be signing that are the actual borrowers. Those are the people that are listed on the applications. Now, if you have a non-borrowing spouse, that person is not going to be on the application. They are not on the loan. They're not responsible for paying back the loan. They will not be signing up at the top. Only the borrowers will be signing at the top. Now, here's one problem. On some of these 1003s, they actually say that this is supposed to be completed or signed by more than one person if this is a joint application. So in other words, if more than one person is borrowing money on the property and they're both on the loan, then they are on the application, then they will both sign. But oftentimes you've only got one borrower. So in this case, you're still going to have them sign, and I'll tell you why, even though it says if it's an application for joint credit, because so many times these processor lenders, they don't know what it says, they don't understand it, and they'll call you up every time and they'll say, oh, you didn't get the borrower's signatures on there, and you try to tell them, well, it wasn't a joint credit, it was just a single borrower. They don't care, they want it there. So I've never had one turned down that had the signature on there. So on the side of safety, go ahead and have them fill it in and sign it. So as you can see here, there is no co-borrower name, so it is just a single borrower. You can see here that there's a breakdown on this one particular one of their employment, how much they earn. There's a lot of personal information in here. You never ever want to talk about it. We have handled some loans where the income was staggering, and it's not something you can talk about because perhaps the person is a celebrity or well known in an industry. You must keep this information private, and this is why it's important that you set up your office in an area where there is no traffic, even if it has to be a closet in your bedroom. This is just another page of this 1003. A lot of the information is there. This should be completely filled out by the time that they get their loan documents. All that information has been prepared and put in there. One of the things I want to mention right now is that you should never notarize any documents that have not been filled in completely. You cannot notarize blank documents. And really, on something like this, the borrower should not be signing anything like this 1003 unless it's been completely filled in. But just remember, that's one of the things that you are not able to do, is to notarize a document that is not completed. This is just exactly what it says. It's a credit score disclosure. This one happens to be for the state of California. This could be anywhere in the United States. Basically just telling the borrowers what their credit scores are from the different reporting agencies. Oh, this is a biggie. I want you to pay attention to this one. This is called an allonge. And an allonge is merely a document that transfers the interest of the note from the one lender to another. So in this case, Americash is the company that's making the loan to these people. But they have, as we've previously seen, sold this loan to JP Morgan Chase. Well, in order to complete the sale, there's two documents that are involved. One of them is this document, which is called the allonge. You don't need to show it to the borrowers. You don't need to have it signed. You just turn it over. But I am talking about it because I do know that a lot of notaries, when they come to this document, they will look at it, not know what it is, and not know what to do with it. And so it takes a few minutes out of your signing time to figure it out. So there it is. Turn it over. Okay, here's another document I want to show you because this will come up for you. A subordination agreement is an agreement that is executed by a lender who, let's say they have a loan on the property, they're in second place. There is a first place lender, and they're being paid off and being replaced by another first place lender. The subordination agreement basically says, hey, it's okay, you guys, you new lenders, you can be in first place, I'm still fine with my second place position. If this were to ever be a huge mistake where the lender did not get a subordination agreement and they filed their paperwork and were on title as a lender, they would drop down into second place. So you'd have somebody that has this huge loan on the property who's supposed to be in first place, now in second place behind maybe a $10,000 loan for a second. So this subordination agreement is not something you do. It's not something you take care of. Every once in a while, you will get one in the package that needs to be signed by the borrower, but it's very rare. But I will tell you that occasionally your escrow will be held up by the lack of a subordination agreement. For some reason, the people who are in second, third, fourth place are not in a big hurry oftentimes to create and execute the subordination agreement. This is a warranty deed. Deeds come in all different forms. There's quitclaim deeds, there's warranty deeds, there's interspousal deeds, disclaimer deeds. Basically, a deed is when from one person or persons who are called grantors are transferring the title to the property to other people or another person called grantees. This is the document that transfers the interest in the property from one person to another. So try to remember this when you see those words, grantor and grantees. It's important for you to know. Sometimes you will get a deed, a quitclaim deed especially, that let's say is from a husband and wife to the husband and wife, but they're changing the name. Maybe they went on title without their initials, and now they want to put their middle initials on there. Or perhaps you have a wife who is coming off of the property. Maybe there's a divorce in the works, or they've already divorced. So you might have a deed from Bill Smith and Mary Smith to Bill Smith as his sole and separate property. This is a document you will not see often, but if you do, basically this means that the people that were on title to the property were probably married. They had their property held as joint tenants, and now one of them has passed away, and the name needs to come off of the property so that it belongs to the surviving spouse. This will be accompanied by a death certificate, a certified death certificate, and oftentimes they will ask you to collect that certified copy of the death certificate and send it back with the loan documents. So here's another type of deed. It's a grant deed. There may be some legal differences between deeds, but that's not your concern. You're not there to advise people, merely to execute the documents and have them signed and notarized. This is another one, the one I mentioned, the interspousal grant deed, and this is used strictly between husband and wife. I mentioned this one. This is a disclaimer deed, and this is often used in community property states where it's automatic that the husband and wife share interest in property. But let's say, for instance, the husband purchased this property prior to the marriage, and the wife has nothing to do with it. She doesn't care. She doesn't want any part of it. She knows it's his property. Maybe he uses it for his business, whatever. So this is just saying, I don't have any interest in this property. I don't have any idea, past or present, to take claim or title to this property, and then they sign off on it. So there's never any worry as to whether the two are on title or not. It's very clear who's on title. This is a certification of a trust. You're going to see whenever there is a trust involved in the property. And basically what this document is, it has to be filled in by the borrowers. It basically says that the trust has not been changed, that everything is the same as it was when it was first drawn. There's been no amendments.